hearing in the appeal Bain against the Queen.
Yes. Well, first of all, thank you for accommodating us in adjusting the time for the start of this hearing. And as you know, we have agreed to sit on this afternoon in order not to deprive you of any of the allotted time. But thank you for your consideration. Yes.
May it please, Your Lords. My name is Martin Lundy.
Yes.
Second, I pair with Mr. Edward Fitzgerald, QC, along with Mr. Mandacliffe Matthews, on behalf of the appellant. My learned friend, Mr. Tom Poole, appears on behalf of the respondent. Just a matter of housekeeping, my lords. I'll just take the court quickly through the papers that the court should have before it. There should be the record of the proceedings in 3 volumes, which is found at pages 2 through 1838. That's 1,838.
I think we've got 4 volumes of the record of proceedings and a supplementary record as well. I think that's correct.
Sorry, it's 4. That's correct. 4 records, my lords, and then the supplementary record. The agreed proceeds is found at page 1839 of the record.
Yes.
The chronology is found at 1859 through 1863. The statement of facts and issues are found at pages 1840 to 1858. The appellant's case is at pages 1980 to 2024. The appellant's further note on ground 1. The appellant's further submissions on grounds 4, 5, and 6. The appellant's further submissions on sentence. That should be the respondent's case, which is found at pages 2025 to 2058. There's the joint bundle of authorities. And then, just for the completeness of the record, grounds of appeal are found at pages 1830 to 1834. My lords, I will present the appellant's case on conviction.
Yes.
And my learned friend, Mr. Fitzgerald, my learned senior, will present submissions on behalf of the appellant on sentence.
Yes, having read the supplementary submissions, I was able to work out that Mr. Fitzgerald would be coming to assist the court in that matter. Thank you.
My lord, so before I begin, I just want to take the court, or ask the court to consider this matter in the following context. This appeal emanated from a murder trial during which the Crown sought the sentence of death. The appellant, Mr. Bain, is a man who struggles to read. In fact, he is self-described as not educated. In fact, he learned to read while he was in jail for the 3.5 years he was in custody before trial commenced. And there's references to that in the proceedings. It's pages 191, lines 8 to 17, 528 at lines 21, and then 529, page 529, line 1.
Thank you.
Mr. Bain was made to represent himself, all because he wanted an additional set of quote-unquote the disclosures, as he put it. It's clear that the appellant understood from the judge that the opportunity cost for copies of documents was for him to represent himself. There was absolutely no other alternative put to him. His counsel was allowed to withdraw, and 1 hour later, trial proceeded.
It does seem that there may have been other reasons for the withdrawal by counsel than the issue of the documents.
Well, my lord, I can only take the court through what happened sequentially. What he said was he wanted the copies of the documents, and that's very clear. And perhaps I should take the court directly to that reference in the proceedings. He was very clear about wanting copies of the documents, and he actually says that was the reason why he chose to represent himself. There was nothing more to it. Yes, there were. He may have had issues with his counsel, but that is not to say that he should have been made to represent himself during a murder trial where the Crown sought the death penalty.
Counsel said he was withdrawing because his client wanted him to present the case his way.
Yes, he said that. But, my lord, and the authorities will show that in and of itself was not sufficient to allow the court to to warrant the court's allowance of his counsel to withdraw. In due course, I will take the court to the case of Maguire, which sets out the myriad of authorities on the point. And so I will ask the court's indulgence until I get to that point in my submissions.
But I think what Lord Lloyd-Jones is indicating, that the board may be reluctant to put on blinkers and take the view that the only reason why the defence counsel withdrew was because of a dispute about copies of documents, because those documents would have been available to defence counsel, and presumably, according to defence counsel, the accused had seen them as well.
Yes, my lords. Sorry, I don't dispute that. No. That is correct. I'm asking the court to consider the totality of the record. The court needs to consider the order of the way things transpired on that very fateful day of trial.
Well, I will let you develop your argument because time is tight.
Much obliged. The Appellant's case before the board is very simple. He had an unfair trial, which was largely precipitated by his self-representation. Because of this, the court should carefully consider the facts surrounding Mr. Bain's self-representation. Why did Bain choose to represent himself? What was the court's position on Bain's self-representation? In the case of Regina and Maguire, which is found in the appellant's note on ground 1, the Court of Appeal, which is a Court of Appeal decision from Northern Ireland, the court set out various principles, applicable principles, established by the board and the English Court of Appeal when counsel withdraws from representing a defendant during a trial of a serious offence. And I refer particularly to paragraphs 80 through 98 of the Maguire case. And my lords, I ask the court I commend those paragraphs to the lordships for review and consideration in the interest of time. The conclusion.
So if you're referring to cases, if you could give us the electronic page number that you're wanting us to refer to, that will enable us to do the necessary reading more easily. So where do we find this reference to Maguire?
My lords, this was served after, so it's not in the electronic bundle.
It's not.
But I can take the court through.
It's attached to the note on.
It's attached to the note, the appellant's note further note on ground 1. And particularly, I'm speaking to paragraphs 87 through 98.
Thank you.
The conclusion the court arrived at in the Maguire case is found in paragraph 98, and I think it's significant that we consider what the court concluded. And the court said, what is apparent from this overview of the relevant authorities is that it is necessary to examine carefully the precise circumstances and facts in the individual case. The outcome of the individual case cannot be determined simply by finding that a defendant was unrepresented or simply by finding that his lack of representation was caused by the failure of counsel to represent him. What is called for in each case is a careful scrutiny of the actions of the defendant, the legal representatives, and the trial judge. So what I'm asking this court to consider here is precisely that. What was the actions of Mr. Bain? What was the actions of his counsel? And what was the actions of the trial judge? On the first day of trial, the appellant attempted to ask the court for a copy of the disclosed material. The appellant said that he would like, quote, would like to have a copy of all the disclosed material so that he was not allowed to stop. The court stopped him and said, Mr. Bain, you have counsel, Mr. Calvin Seymour. The jury was then excused. The appellant again attempted to address the court. The court reminded the appellant that he had counsel. Mr. Seymour then says, well, it appears I may not be competent to represent the appellant. Mr. Seymour also said that the appellant is asking him to do the case his way and later asked the court to excuse him in these difficult circumstances. Now, nothing further was said about what made the circumstances particularly difficult, only that the appellant wanted him to do the case his way. However, it is important to note that a client is always entitled to instruct his attorney whichever way he chooses, and it is the obligation of counsel to follow those instructions, regardless of how difficult they may seem. Surprisingly, the court agreed with Mr. Seymour and then criticized the appellant, saying to him that he would, quote, run into difficulties if he withdraws. You're going to deal with your case by yourself. So she didn't give him any other option. That's what she said to him. And that's at page 53.
He'd already dispensed with the services of previous counsel, hadn't he?
Sorry. No, yeah, Roberts wasn't available.
Right, so it wasn't a case where he'd sacked his first counsel?
No.
Right. Thank you.
It is important to note that at the time, the only option put to the appellant, if the court considers page 53 of the record,
Yep.
Just really quickly. Yeah. And then at paragraph 18, I don't know about that law, but Mr. Roberts asks, no court will grant, so sorry. Yeah, the court says, if you need another set, then you have to do that your only expense. You are legally aided, the Crown is already doing a lot, the state is already doing a lot to provide you with a lawyer of some years' experience. Because Mr. Seymour is not a lawyer who just came out of law school, and so you, as far as I'm concerned, if you want to conduct your own case, you can do so. But you will not get two documents at this time after numerous case management conferences. And the court then went on to state the very many case management conferences in this case. My lords. Yeah, and that's at page 54. At page 54, the line 7 and 8, just to answer my lord's question about whether Mr. Jerome Roberts was fired or not. It says Mr. Jerome Roberts appeared. I see no record of two sets of documents. And he says then, there's line 10, then the 11th of May, Mr. Roberts withdrew from the case on the day, saying that he had other commitments.
Thank you.
Okay?
Sorry
about that, my lord.
Very grateful. Thank you.
Okay. It is important to note that at the time, the only option that was put to the appellant in the event that Mr. Seymour was allowed to withdraw was for him to represent himself. The option that he could secure alternative counsel was not put to the appellant. Upon review of the transcripts, it is clear that the real issue of the appellant was not that he was seeking to direct Mr. Seymour on how to conduct his case, but that the appellant says that his prior attorney, Mr. Roberts, had asked for two disclosures, one for his counsel and one for himself, and that's at page 53, line 10 of the record.
So if he wanted to get alternative counsel, what would the procedure have been?
Well, he could have indicated that to the court. He would have indicated that to the court.
But what would the procedure have been? How easy would it to get alternative counsel?
It would have resulted in adjournment.
Yes.
And he would have to, I'm not going to say to this court that I'm particularly versed in how he was going to obtain another counsel by way of legal aid. But I will say that the only options available to this appellant was not to just proceed on his own because he wanted another set of papers. He could have, even if he decided to, based on all of what was happening, if he had decided that he wanted private counsel, he was open to do that. But even that was not canvassed with the appellant. And we say, and I say, that is part of the unfairness.
I just wonder whether nobody raised it because nobody saw it as a realistic option. I don't know what the procedure is, but at that stage to get alternative counsel.
Well, I think the trial really had not started. So
Jury had been sworn in.
So I think that he could have gotten counsel. He could have secured alternative counsel if given the opportunity. He could have. There's no evidence to say that he couldn't. Surprisingly, and I should take the court to paragraph 55, line 10, and he says, my lady is telling me only way I could get copy of the material if Mr. Seymour is not representing me, is if Mr. Seymour is not representing me anymore. So for that reason, I need the copies. I represent myself. So it's very clear that that is what this appellant was concerned about at that moment during and then he says, for that reason, I represent myself. And the court says, you will represent myself? And he says, for that reason. That's lines, page 55, lines 10 through line 15. The appellant was asking for a copy of the discovered material, and the court said that his prior counsel could not ask for that, and the Crown can only disclose one.
Yes, please.
And that is at page 53, line 12. Mr. Seymour then explained that the appellant was apparently seeking two sets of documents, one for himself and one for his counsel. And I respectfully submit that that is not unusual. I understand the practice here in England is for the appellant, the defendant to actually have a set of documents. The trial judge resisted the appellant's request and said that no court will grant that order because that means additional expense on the Crown. And the Crown is only under duty to disclose to your lawyer one set of documents. The court then advised the appellant that the Crown is already doing a lot, and she says, and this is at page 53, line 28, so as far as I am concerned, if you want to conduct your own case, you can do so, but you will not get two documents at this time after numerous case management conferences. And that's at page 53, lines 31. The court then becomes very protective of Mr. Seymour, and he says, your lawyer has them if you don't need your lawyer. And she says, quote, I know Mr. Seymour will withdraw from this case very quickly. Firstly, it is unclear how the trial judge knows. And secondly, she goes on to say no lawyer wants to be put under that kind of pressure. But the transcripts, upon review of the transcripts, it's not clear what that pressure was.
It's not clear what?
What that pressure was. She says no counsel wants to be put under that kind of pressure. All he was asking for was another set of documents. But that...
Well, with respect, Mr. Lundy, before the document issue is focused on page 52, doesn't it start at line 22?
Page 52.
When he says, my lady, it would appear that I may not be competent.
Yes.
Competent to represent Mr. Bain.
Right.
He's saying I must do it his way, and if I have to do it his way, I must ask the court to excuse me in this difficult circumstance. Right. That seems to be the crisis point, doesn't it?
Well, I do agree that that's part of the issue, but we do not know what doing it his way means. That is not an evidence. That's not borne out in...
No, but one assumes that Mr. Seymour is an experienced criminal lawyer, is he not?
Right.
Yes, one must assume that it's not just a question of tactical preference. He must have been put in a position where he felt he could not continue to act.
Well, my lords, I asked the court to consider this. In the case of Maguire, and I was going to take the court to that in due course,
yes.
Maguire sets out a number of guidelines which is enunciated in various cases. And I think in one of them, I should take the court directly there since it's an issue. Yeah. And the court says some guidance as to the relevant principles can be obtained from a number
you're
of
reading
people.
from?
Oh, sorry, this is page 29, paragraph 87 of the Maguire case, which is found next to the further note on ground 1.
Looks like that.
Further submissions on ground 1.
I think it's appellant's further note on ground 1.
Yes, I don't have that document.
We have a spare, my lord.
Thank you very much. Thank you very much, Mr. Lundy. No, I haven't seen this document.
And so at paragraph 87 and the following paragraphs, there were sub-paragraphs, the court set out, considered Robinson and Regina, that's at A, subparagraph A, subparagraph B dealt with Dunkley and Regina, and subparagraph C dealt with Mitchell and Regina. And I just want to take the court to the dicta in Dunkley,
Thank you.
which is on page 30, and if the court looks at that quoted section, it says the judge did not exactly encourage counsel to withdraw, but he made no attempt to dissuade him, and it does not appear that he considered the possibility of the first defendant trying to obtain alternative representation. So, my lord, even if that is the case, that the issue for Mr. Seymour at that time was that he could not proceed in those circumstances, whatever those circumstances are, it cannot be the case that the option would be for this accused to represent himself. Then would have been the time for the judge to actually attempt to persuade him to continue on with his representation, or in the very least, say to the appellant that you need to find alternative counsel. And that was not done. And that's why I say, my lord, it's very clear when you read further that the issue for the appellant was only the set of documents. That's what it was about. He wanted another set of documents.
But that may be the catalyst, but Seymour was wanting to withdraw because he felt that he was compromised in some way. But that may not matter, because your point is, for whatever reason, Mr. Seymour felt he had to withdraw. You say, based on Dunkley and Maguire, you say the judge should have taken further steps to protect the accused person facing a capital sentence.
That is precisely the
Yes.
point, my lord.
I think you might want to get the Mitchell case and the Dunkley case. The Mitchell case specifically approves the approach in Dunkley at page 428
Right.
as to what should happen where counsel is going to withdraw. Sets out various steps.
Right. Sorry. I'll undertake to provide it, my lord. So, my lord, since I'm already here, I think the court it appears to me that this court has already read the transcripts. So, in the interest of time, I'm just going to make the submissions from the Mitchell case. Before I begin with Mitchell, I actually think I should deal with Robinson.
When you say read the transcript, to what are you referring?
The transcript in the trial transcripts. I mean,
I see.
the court seems very well versed.
You should not assume that the court has read the whole transcript from cover to cover at this stage. I mean,
Right.
what we undertake to read is the judgments of the court below at the cases. So if there are critical passages in the transcript, do not assume at this
Very
stage that they have necessarily been read in the way that you're suggesting.
Very well, my lords. I'm guided. Okay.
But by all means, you can refer us to page numbers, which
Right.
we can read later.
Much obliged.
Thank you.
After the judge informed counsel that, the appellant that the Crown was only under duty to disclose one set of documents, the court then went on about how the Crown was already doing a lot. And she says to him, if you want to conduct your own case, you can do so. The court then, sorry. I think I already addressed that about the, so I'll just read further.
Yes, you would refer us to the bottom of electronic bundle, page 53, and the top of page 54,
Right.
where she said if you want to conduct your own case, you can do so.
And that no lawyer wants to be put under that
Yes,
kind of pressure.
and you're saying that is inconsistent with the guidance in Dunkley and Mitchell.
That's correct, my lord. And so the question is, undoubtedly whether the defendant would have suffered prejudice by the withdrawal of counsel. And just so I could take the court back to Mitchell, or take the court to Mitchell, which is found on page 31 of the note. It's McGuire, which is found in the note on the further note on ground one, sorry.
So we're going to the note paragraph.
Yes, so that'll be 87C.
Sorry, paragraph.
Paragraph 87C.
Yes.
Yes. We're looking at the description of Mitchell and Maguire. Yes.
That's correct.
Have you got the actual case? I think it would be helpful.
It's not in the bundle, is it?
We're getting it, my lord. If I may proceed until we get the original.
Please do.
In Mitchell and Regina, which is also a capital murder trial, on the second day of that trial, after the second witness for the prosecution had given evidence, the defendant's leading counsel told the judge in his presence of the jury that the defendant wished to cross-examine the witnesses himself. She asked the judge to allow her to terminate her assignment. The judge told the defendant that if he rejected his existing counsel, he would be on his own and that the judge would not provide him with different counsel. The defendant made allegations against his leading counsel, and it became apparent that he did not wish to continue with either of his counsel and no longer wished them to represent him. He did not apply for an adjournment to investigate whether other counsel could act for him, and he was not advised to do so by counsel or the judge. The judge permitted both counsels to withdraw, and the trial proceeded without the defendant being legally represented. He was assisted by the judge in questioning witnesses, but did not understand the correct court procedures and was at times confused. He had little opportunity to establish his alibi. He failed to indicate two errors in the judge's summing up. Privy counsel quashed his conviction. On the analysis of what happened at the trial counsel's withdrawal could not be said to have been the result of any fault of the part of the defendant. One thing that was clear to the court was that his counsel in all the circumstances did not wish to act for him. He was not content to continue with them. Their lordships rejected the prosecution argument that the criticism of counsel was all an attempt to manipulate the proceedings so as to get rid of counsel. To attribute all of the responsibility for what had happened to the defendant as having of his own volition dismissed counsel seemed to the court to be putting too heavily against the defendant. His comment that counsel did not want to defend him seemed accurate. The trial judge had not told the defendant firmly that he would not provide alternative counsel. This meant that the defendant was left with no other choice than to continue either with the existing counsel or to do the case himself. The judge could not have been satisfied with the defendant, that the defendant would not, or at any rate, might not suffer prejudice by the withdrawal of counsel. The lordships were satisfied that there should have been an adjournment to see whether other counsel were able to represent him, or at least to advise him as to the courses open to him. It was only after such advice that he could properly reflect on what he should do in the situation in which he found himself. And so, my lord, that passage is so apt to the present case. These enunciate the principles which I spoke about earlier. The fact is, the judge did not explain to the appellant that he had an option to secure another counsel. The judge did not explain to him, or even try to dissuade Mr. Seymour from withdrawing as counsel. So it seems to be the case that, and I do accept, my lords, that fact, the fact that he was left self-represented at trial, is not in and of itself sufficient to find that his trial was unfair. And I refer to the case of Dunkley again, and that case talks about the cumulative effect of self-representation. In that particular case, and this is found at page 30, subparagraph B of paragraph 87. And I should say, regarding withdrawal of counsel, the court found that the judge should do whatever was possible to persuade counsel not to withdraw during the trial. If the proposed withdrawal arose from an altercation, the judge should consider whether to adjourn the trial for a cooling-off period, and in any event, he should only permit withdrawal if satisfied that it would not cause prejudice to the defendant. And I think that's the point here. I think your lordships referred me earlier to the fact that Mr. Seymour said that Mr. Bain wanted him to proceed by doing the trial his way, and that presented great difficulties for him. But I liken that to an altercation. That's really what it is between counsel and client. And in circumstances such as that, Dunkley is very instructive here that the court should have adjourned the trial and allowed for quote-unquote a cooling-off period. At least that was one option, I submit, was available to the trial judge.
There's an instructive passage in Mitchell on the penultimate page of it, I think, which sort of sets up the structure of how the court ought to approach a situation in which something's arguably gone wrong with regard to counsel that they there conclude that the judge couldn't have been satisfied that there wouldn't be any prejudice from the withdrawal of counsel. They then look to see if the judge has considered if the trial could be adjourned so that other representation could be obtained. That's Dunkley. They look to see whether it could be said that the lack of representation was due to the man's fault, or whether it was one of the most exceptional cases where a reasonable adjournment to secure alternative representation wasn't required. So it's a structured approach which is quite useful. So if you have got the copy of Mitchell,
We are, my lords, we are getting it. It's on its way. I'm terribly sorry for this.
it's on page 1687 for anybody who's got it.
So, my lords, the point I'm making here is that no adjournment was given. No other options were given to the defendant. In Dunkley, the summary, which is stated in McGuire, says, if a defendant was left unrepresented through no fault of his own interest of justice, through no fault of his own, the interest of justice required that in all but the most exceptional cases, there should be a reasonable adjournment to enable him to try and obtain another legal representative. I've already referred the court to the passage about dissuading the judge, not dissuading counsel from withdrawing.
Mr. Lundy, one feature which Dunkley and Mitchell appear to have in common from these summaries is that in each case it was through no fault of the defendant that his counsel withdrew. Now here we're a little bit in the dark on that, aren't we?
Well,
because we know there was a dispute about the copies of the documents. Maybe said that the defendant was being unreasonable in insisting on a second set for himself. But there's also, as my lord says, that may well just have been the catalyst. There was something more fundamental going on, because his counsel Mr. Seymour was saying that he was in difficulties, and we don't know the reason for that.
Well, this is precisely the point, my lord. I am of the view that the judge ought to have explored those difficulties, and ultimately should have tried to convince Mr. Seymour that he should have proceeded in the circumstances. And I submit that that simply was not done. In fact, the judge seems to have encouraged him, and then the defense counsel encouraged Mr. Seymour to withdraw. So I cannot say, my lord, that is, upon review of all of the authorities, that was actually fair to the appellant. And I accept, as I said before, that that in and of itself does not necessarily amount to an unfair trial, but the judge this is Lord Johnsey in the Dunkley case, discusses the cumulative effect of the matters which would warrant a conviction unsafe. And the Lordships would, however, wish to make it clear that while the facts in this case warrant the foregoing conclusion, it by no means follows that the same consequences would flow where the appellant's only complaint was that he had been left unrepresented at some stage in trial. And I submit that that's not the only complaint here. So respectfully, Mr. Bain does not fit within, it's not as if he's saying his trial was unfair because of the fact that he was unrepresented. We submit that he was severely prejudiced, and there were a number of instances of his unrepresentation, or his lack of representation, which resulted in a number of things unfortunately going awry at trial, not least of which is his inability or ineffective cross-examination of the prosecution's chief witness. And I will take the court to that in due course. So, my lord, I will park Mitchell for right now until we get the full version of the case. I wanted to refer the court to Robinson because the Court of Appeal found that Robinson, and actually cited, quoted Robinson in its judgment, and the Court of Appeal found that Robinson was found that the short time span between the withdrawal of counsel and the resumption of the hearing was not seriously prejudicial to the appellant. But if the court considers the Robinson case, it is clear that on the present...
Where do we find Robinson?
Oh, sorry, Robinson is found at tab 21 in the bundle of authorities.
And can you give us the electronic page number as well?
Sorry, it's at page 2310. And I'd just like to take the court to the following passage in Robinson, which is at 2312. And it says here that the judge, it's 2312, and that's at B, the paragraph at B. The judge was determined to proceed with the trial, and although there had been a long history of delay that was through no fault of the defendant, the judge dominated the proceedings and played the role of prosecutor, judge, and defense counsel. Defendant clearly did not understand what was happening. His legal advisors had deserted him.
Yes, it sounds like submission.
Yes, it is. But sorry, but in any case, that is instructive. That is helpful in these circumstances. And I would submit, my lord, that if the court considers that those submissions made in the Robinson case, they're almost identical. They can almost, word for word, verbatim can be made in the present case. So that's why I flagged that. Sorry, my lords. Okay. And on the point about the judge being determined to proceed with the trial, there's a number of references that I'd like to take the court to, which speak to precisely that. Page 76, line 28, 83, line 15.
Sorry.
76, 28, 83, 15.
84, line 8.
I'm sorry, these are references to what?
So the judge's insistence on the trial proceeding.
This is from the transcript. These are pages of the transcript.
Correct.
Could I have the references again, please?
76, line 28.
Yep.
83, line 15. 84, line 8. 85, lines 27 through 29. 97, lines 88 through 11. Yeah, and she kept saying that, we have to finish this case, we have another case coming. So all of that should be considered, this case should be put in context of that. We were dealing with a judge that was really trying to press on with things. But in Robinson, the conclusion, and it says, and that's at page 2328, putting a generous and purposive construction upon the subsection, and they're talking about, my lords, the Constitution in particular, which talks about the fundamental rights and freedoms. Putting a generous and purposive construction upon the subsection, we have no doubt that by taking the course which he did, the trial judge failed to permit the defendant to defend himself by a legal representative of his own choice. The effect of his decision to continue the trial without adjournment after the withdrawal of the defendant's counsel was to deny the defendant the option to which the Constitution entitled him. Indeed, it is difficult to imagine a more serious turn of events for an accused facing a capital charge than to be abandoned mid-trial. So this was the dissenting judgment in Robinson.
It's the next part as well. Not just abandoned mid-trial by his legal advisors and to be denied by the court the opportunity of replacing them.
So this is the dissenting judgment, but Maguire basically adopts this. So. Yeah, and he says at page 30 of the note of the Maguire case, which is found at the further note on ground 1. On that same passage that I read, it is difficult to imagine a more serious turn of events for an accused facing a capital charge than to be abandoned mid-trial by his legal advisors and to be denied by the court an opportunity of replacing them.
I'm sorry, you're reading from Maguire paragraph?
Sorry, Maguire, page 30.
Page 30, right.
And if you look at the top, and it says, the very first quote, it is difficult to imagine.
Thank you.
Yeah. And the Lordships in Maguire says, of that passage, there can be little doubt that the approach adopted by Lord Scarman and Lord Edmund Davies would stand up to greater scrutiny in an Article 6 context than the opinion of the majority. So,
thank you.
So the fact that Mr. Bain, before I move on, my lords, I understand the courts should now have the full copy of Maguire.
Mitchell.
Mitchell.
Sorry, Mitchell, sorry.
Now, the passage I was referring you to is 1686 at C, where the board approves the approach in Dunkley in the quote which is then set out.
Right.
And the present case, it had formed the view, was one in which the accused, rightly or wrongly, had formed the view counsel didn't want to represent him. That is 1685A. It's that approach there which is then been applied, and it may be quite instructive.
1685A? 168?
That's where they say what the case was like,
Oh, yeah.
what was on the facts. But as to the approach, it's 1686C, setting out that passage in Dunkley,
Right.
the approach to be followed.
Yes, I see it, my lords. And that passage is instructive in the present case. And I just want to rewind just a little bit. I spoke about the fact that the appellant was unrepresented, not being the only point, not being sufficient to lead the trial, to lead the court, to this court to find that he had an unfair trial. I said that there were other factors. One of those factors, I referred the court to that, was deprived of the advantage of competently cross-examining a key witness, and that witness was Zena Davis. The fact that he did not competently cross Zena is dealt with in the Appellant's case. Davis was the Crown's primary witness. It was she who identified the Appellant from the blurry CCTV footage of Burger King. It was also Davis's evidence that the Appellant confessed to her that he had murdered the deceased. Davis's evidence was therefore critical to the Respondent's case.
Yes, I mean, it might be thought that the confession to Davis was perhaps stronger than her recognition of him in a blurred image.
Right. Well, my lords, even with that, we say that there were issues with even that.
But you say that he says he may have been framed by Davis.
Right. And there are other factors that should be considered. Throughout the trial, we learned that Zena and a friend was also in custody around the same time that Bain was in custody. The jury asked the judge about this, and I think I should take the court directly to that. The jury asked the judge the following question. Let me just find it. Let me just find it. Yeah, it's 192 of line 15. 192 line 15 of the record. 192. Sorry. 192. Yeah. There's a number question. There's number question on number 3. What is the reason for Tamika and yourself to be held in police custody? It is important. It's not important to these pleadings. This is what the judge's response was. It is not important to these pleadings, and she may not be able to know the reason why they were in police custody. So it's not relevant to these proceedings, okay? We are only concerned with Mr. Bain. He's in the dock. The young lady is a witness. She's not sitting in the dock there. So that one will be disallowed. And we say, my lord, that was egregious. The fact of the matter is, even as a witness, the fact that she was detained or arrested, that could have gone to her character. If it is the case that she was detained with respect to this murder, the murder subject of these proceedings, then we say that was a ripe question. That was a question that should have been asked and should have been answered. And we say the fact that Mr. Bain was not represented by counsel, competent counsel, or any counsel, is an example of the unfairness visited upon him here, or the prejudice he suffered, because a competent counsel would have, so to speak, made a dog's meal of that.
Do we know why Miss Davis was arrested?
No, we don't. No, we don't. No, we don't. Now, we bear in mind that, and I should take the court to it doesn't, that's not borne out on the papers. The fact that Mr. Bain did not cross-examine Davis, I would like to direct the court to page 1264 of the record, and that's at line 22.
Sorry, 264.
1264. Page 1264.
Right.
Volume 3, I think.
Volume 3. page 1264. Line 22. And this is the judge during summing up. In her sum up. As I recall, I do not believe that the defendant cross-examined Zina about the alleged lies she told the court. But in his address to you yesterday, he invites you to find that she is a liar. So, Your Lordships, I say that it's unquestionable whether the appellant actually cross-examined Zina or adequately cross-examined Zina. The fact that the judge even makes that statement is significant to that point.
But there was in fact very little cross-examination by him.
Of Zina, that is correct, my lord.
Yeah.
And we say, had he had competent counsel, my lord, he would have picked apart Davis's testimony. In the appellant's case, I discuss the various issues I found in Davis's testimony. And I can begin with the fact that identification or recognition, whatever we want to call it, began with uncertainty. When asked by the court if Davis remembered what Bain was wearing, she said she originally indicated a black jeans jacket and pants, and then said, probably a beige or so shirt or something with some white tennis, I think, if I could remember. So she's not that's at 169 line 6, but these are in my case, my lords.
Sorry, where in your case do we find this?
Okay, we're at, just a second.
696. I didn't even.
I was checking something else. What page are we wanting to look at?
We were looking at page 169 in bundle 1, I believe, which is the record, and Council's looking up the references in his case.
Yes, that's it, my lord. Thank you very much for that.
I'm sorry, I didn't hear that.
It's at page 1993 of the record, paragraph 63.
Thank you.
And the following paragraphs. It would be seen immediately that Davis, who has been asked to identify the appellant on the video from the back by references, clothing, and size, she hedged and she was very uncertain, saying probably from inception. And I'm just identifying issues in her examination, which, if had competent counsel, had Bain been represented, I'm sure that during cross-examination, his counsel would have explored all of these inconsistencies, or I say inadequacies. Davis is taken to the video itself, and then when asked by the Crown, can you see the image there? Are you able to recognize anyone in that image? Her immediate answer was, prevarication. You look at page 185 of the record, that's in volume 1, 185. Line 4. Ms. Davis, can you see the image there? Are you able to recognize him? And she said, it's kind of blurry, but I could recognize it. And then she said, well, who do you recognize? And then it follows.
Factual sequence of events as the evidence presented it of the period around this before they arrived back at the outlet again. Because I wasn't sure, having read the summing up, precisely what it was said was the sequence of events. He picked up the victim at some point.
Yes, and then he took the victim to Burger King, and I'm just summarizing here. He took the victim to Burger King, He tried to get him to open up the safe.
Yeah, this is what immediately leads to the murder allegedly.
Yes,
But I'm asking, because what we've just been looking at is Miss Davis speaking of the clothes that he and Rashad had on before he left. So I'm trying to put that into the picture of the sequence.
Oh, so are you asking me what happened before? What did she say happened? What did Zena say happened?
At some point, she saw them in the clothes that she then identified them as wearing in the video footage.
Yeah. Well, according to, I direct the court to page 166 of the record. It says, she says that Saturday came and he was going to pick up Rashad. This is what she's saying that Bain told him. She picked up Rashad from downtown from by work. And he was going to bring him back by the apartment. And he wanted me to be in the back of the apartment where he reached there so Rashad wouldn't see me or anything like that. Well, did he go back? And the question was asked, well, did he go and pick him up? And the answer was yes. And did you go back to the apartment? Yeah, he would call me. Before they reached there, when they're almost there, he would call me and he would be like, he talking to me on the phone. He would be like, baby, I like a minute away, so I would know to go in the back of the apartment. And yes, I went in the back of the apartment. And that's when he pulled up. A couple of minutes after, he pulled up, him and Rashad. And the question was asked, and what did he pull up? It was in his car, a black Honda Civic.
So this was earlier on the same evening?
Earlier on the same evening.
This was him picking up the victim, bringing him to the apartment where Miss Davis was.
Right.
Miss Davis goes into the back of the apartment,
Right.
but she did see Rashad and what he was wearing.
Right.
Yes.
Sorry, if it helps the board, I think 12.4 and 12.5 of the SFI sort of set this out in fairly succinctly, which is page 1848 and 1849 of the record.
I need to see that. So, can I move on? Okay. So, aside from those issues, can you see the image there? Are you able to recognize the image? And she's saying that the image was so blurry, but she could recognize it. And I touched on this earlier, that, and I'll direct the court to 187, line 31, which shows that Zena had been arrested on December 25th, so Christmas Day she was arrested, December 25th, 2009, and was still in custody on the 1st of January 2010.
Forgive me, where does that appear?
Sorry, that's at page 187.
If you go back to 186 at line 25, you see the beginning of the cross-examination.
Right,
And the page 187 is part of that.
right.
He's asking about her presence there.
Sorry, my lord.
It actually concludes the cross-examination at 189.98. So it's only 2 odd pages of cross-examination.
Yes.
He does ask a few questions later.
Yes.
But that was really all he put
Yes.
at the start.
Yes, and that's precisely the point that I'm making, my lords, that based on the responses Zena Davis gave during her evidence in chief, I think rigorous cross-examination was necessary, was absolutely critical seeing as she was the key witness in the defendant's case. In the Crown's case. And I would even go a little further to demonstrate another example of how Bain's unrepresentation or his lack of representation adversely affected him during this trial. The court may be aware that there was a confession statement signed Bain signed a confession statement. Bain's case was that that confession statement was essentially beaten out of him. A voir dire was concluded, and the court ultimately determined that the Crown had proven that he was not oppressed in any way. But I want to take the court to.
Do we actually have the confession statement and the interview statement? I don't think they're in the documents, are they? It would be quite helpful to have the documents.
You don't have them.
It was read in the evidence, but I wonder if we actually had the documents.
No, okay. 2654, so volume 265.
This is mine. This is a copy of 115. This one here. But
Miss Davis gives an account at some point in her evidence of having seen Mr. Bain on the floor.
Yes, she did.
In the police station.
She did.
And forgive me, and that doesn't seem to have been followed up.
No, it doesn't.
In the questions.
And actually, she went further during the re-examination, and this is the point that I want to stress to this court. She went further. She says, unprompted, and that's that. I take the court to page 189 of the record. This is really significant here. Page 189. Yeah, 189, line 19, and this is during re-examination no less. And she said, page 189. Let's start at line 13 so the proper context can be seen. Question: now you answered in an answer to a question from the accused when he asked you if you noticed where he was in CDU when you came in, and you said he was on the floor. And she said, yeah, And the question was, you remember you told us that? And then she says, unprompted, your lords. Yeah, he was on the floor while he was getting beaten. Unprompted, he said that. She said that. And the question was asked, by whom? And the answer was, well, by people around. Respectfully, my lords, he was in CDU. The people around could only have been officers of...
Well, I mean, you have to read the whole thing. Yeah. She didn't see anyone hitting him.
Yeah.
But he was on the floor and he looked scared.
Right.
That's what she saw.
Yes.
And one infers from that she thought that he'd been beaten.
Well, see, my lord, that is one way that you can infer that that is what happened, but in cross-examination, perhaps it could have been put to her that she actually did see him being beaten on the floor, because she says that, yes, he was on the floor, well, he was getting beaten, and then she says, by whom? By people around. That seems very clear, very unequivocal. There was no prevarication there.
Well, we have to read the whole answer with respect.
I understand that, my lord, but if you consider her response, when prompted, she says, by people around. She then says, I didn't see no one hitting him. But the integral part here is her initial response, her first response, the very first thing she says when she says, you remember, you told us that. And she says, yes, he was on the floor. Well, he was getting beaten. I think the court should take significant note of that fact. In any case, the point here is that had counsel represented Mr. Bain, counsel would have pressed her on this point. I accept that it was during re-examination, but I would submit that this being new, because a new point was arose during re-examination, he would have had an option to...
Yeah, but you've got it in cross-examination at 188, line 19. Mr. Bain asks the question, was I sitting at a desk or any place else? You was on the floor. You was on the floor. Yes. So you have on cross-examination the eliciting of evidence that he was on the floor.
Right.
And your point, I take it, is that a skillful cross-examiner would want to know considerably more about what an accused person
Was doing
or
on
a
the floor.
suspect was doing on the floor of a police cell.
That's precisely the point. My lords, the point here is,
Well, and forgive me, I thought you were going a bit further, because in the re-examination, Miss Davis goes further and says at one point that she understood him to be getting a beating.
Yes.
It's true that was explored by the prosecution counsel, but I was understanding your point to be that ought to have been explored by competent defence counsel.
yes, that's exactly the point.
And in fact, if you look at page 190, line 23,
199,
Mr. Bain is then asked if he wants to ask further questions. He says yes, but rather than picking up on that point, he simply asks some question about cell phone number,
yes.
which finishes at line 3 of 191.
Yes. But that only shows, my lords, that goes to my point. His cross-examination was woefully inadequate.
Yes.
I do accept.
I don't think we're at odds. I mean, the fact that you got that it was the re-examination that elicited the answer that she believed he'd been beaten. What your point is that a skillful cross-examiner, having elicited that he was on the floor, would have been asking a lot more questions at that stage. And if he or she didn't get the answer then, and this came out on re-examination, would apply for further cross-examination.
That's exactly
Yes.
the point.
I understand your position. Thank you.
That is not, his lack of cross-examination or inability to cross-examine is not the only point that I addressed or that I'd like to ask this court to consider. The other points are about, I think, are aptly dealt with in grounds 4, 5, and 6 of my submissions. Sorry, grounds 4, 5, and 6 of this appeal. To mount that point, my lord, the appellant lodged a further submissions on ground 4, 5, and 6.
Yes.
Yes.
Grounds 4, 5, and 6. And simply put, the simple submission here is that had Mr. Bain been represented by counsel, his counsel would have articulated the need for Dr. Reddy, who was the examining doctor, the doctor who examined him routinely after he made his complaints about being beaten by while in custody. The fact that Dr. Reddy was not called for cross-examination is significant. Since this appeal, the Court of Appeal has offered some guidance in the case of Stubbs and Regina. And when I say Court of Appeal, that's the Bahamas Court of Appeal. And I'd like the court, I think the court has those copies, a copy of Stubbs.
Yes.
Yes, it's been handed up loose leaf. Yes.
And I would direct the court to paragraph. You think I should say something? Well, refer to paragraph 156 of the Stubbs case. And it's very clear. We're dealing with the same provision, section 120 of the Criminal Procedure Code, which reads, any document purporting to be a survey for the purposes of within the meaning of the Land Surveyors Act, or, and this is the one here that the court should be concerned with, B, a report made under the hand of an analyst or any matter or things duly submitted to him for examination and report shall be receivable in any criminal proceedings in any court as evidence of any matter or thing contained therein relating to the survey or examination as the case may be. Now, and then it says, notwithstanding subsection 1, the court may have its own motion or where it appears desirable in the interest of justice, and that's key, my lords, desirable in the interest of justice, on the application of any party to the proceedings require the person who did the survey or the analyst to attend before the court and give evidence. I then take the court to paragraph 167, which says, in our view, the provision of section 120 and the ability to introduce a prejudicial and disputed report without giving an accused the ability to cross-examine the maker of the report is a discretion that must be carefully exercised. And then at paragraph 201, of that same case, the Court of Appeal says the burden is always on the Crown. A defendant ought not to be deprived of that opportunity to examine the analyst as to the cogency of his evidence unless there are compelling reasons which this cannot be done. Compelling reasons why this cannot be done. This was not a circumstance of a vulnerable child witness or where public interest required that a witness be protected, nor is this a circumstance where the analyst was dead or could not be found. As pointed out earlier, the trial judge held that not all reasonable steps had been taken by the Crown to have him testify, and pointed out in his rulings there was no explanation as to why Mr. Hicks's evidence could not be taken via video conference or that any attempt was made to do so. I think the court should consider what transpired in the court below. So I'll take the court to page 362 of the record. Lines 27. Mr. Bain, this is the court to Mr. Bain, to the appellant. The doctor would like to refresh his memory from the notes. It is normal practice that we allow them to refresh their memory, okay? And the accused says, yes, ma'am. Now, this doctor is not the doctor who made the report. So, respectfully, how could he be called to refresh his memory? I mean, 361, when the court asked for him to be deemed an expert in general medicine. Page 361 looked at line 12 and the following lines. And this is where the Crown Counsel was asking for Dr. Johnson to be deemed an expert in general medicine. And the court asked Mr. Bain for any objections for the doctor to be deemed. And the accused says, no, ma'am. And the court says, he's given evidence many times in the court. Yes, okay, so you have no objection to him being deemed an expert? The accused says, no, ma'am. Okay, thank you. I deem Dr. Johnson an expert in general medicine. Let's press on. So all of these things, should be considered, my lord.
Well, I suspect you would say that Dr. Reddy was actually a witness of fact as well as a witness of opinion. So just deeming him an expert in general medicine when Dr. Johnson stood in wasn't going to cover the problem point, which was that somebody wanted to put to him what physical signs were seen on the defendant.
That's precisely the point.
Which is a mix, possibly, of fact and opinion.
I accept that, my lord. I accept that, my lord. And that's precisely what we are saying here. Dr. Reddy ought to have been made to attend for cross-examination, him being the author of the report, and replete throughout, even when Bain was cross-examined by the prosecution on the question of his oppression and what was said or what wasn't said in the report. At one point during that exchange between the prosecution and Bain, he says, the prosecution asked him, Just a minute. It's in the cross-examination of him as... Yes. Yes, please. Yeah. Yeah. Yeah, he was cross-examined by the prosecution on what was not in Dr. Eddie's report in order to suggest he was making that up as he went. And so, as a point of reference, I'd refer the court to page 416 of the record, at lines 5 through 18. And she says, you saw the doctor, Dr. Hastings Johnson, come and give evidence for Dr. Eddie this morning? And he says, yes. And according to the document, you also have the document in your...
I'm sorry, you're on 415.
416, line 5.
Thank you.
Line 5, Dr. Eddie this morning. And according to the document, you also have the document in possession. And she says, did you see anything about a plastic bag being held over your face? And he says, I don't remember that. Isn't it so, sir? You didn't see a plastic bag over your face because it never happened. I know, and he says, I know it happened. You were making it up as you go. And he told her, no, I lived that. Now, sir, while the police brutality continued, was not one protocol. Well, that goes on. But the point is here that he was cross-examined on what was not in Dr. Reddy's report. At the conclusion of the evidence, the prosecution counsel's submissions to the judge extensively relied on Dr. Reddy's report to show that the appellant did not tell the doctor about some aspects of the police oppression that he had described in court. The prosecution alleged that this meant the appellant's account could not be relied upon. It's important to note that at no stage during the trial was it asserted that Dr. Reddy was unavailable to attend the trial, nor was there any evidence of any attempts that had been made by the prosecution to call to give him evidence. The court was merely informed that by Dr. Johnson that Dr. Reddy had retired, and as far as Dr. Johnson was aware, was not in the jurisdiction.
Have we got Dr. Reddy's report?
It was read out into the transcripts.
Yes, I think we see it at page 365.
And there was also a diagram. So
Yes, there was a diagram.
I mean, Dr. Reddy, it's the letter of 5th January 2010. It's a fairly short letter with 2 bullet points identifying superficial abrasion on ankle and wrist and superficial scratch marks on the anterior aspect of left leg, otherwise physical examination unremarkable.
Right.
Yeah.
And then,
Mr. Lundy, did the judge, in her summing up to the jury, at any point refer to the disadvantage at which Mr. Bain was put as a result of not being able to cross-examine Dr. Reddy? I mean, I've looked for this and I haven't been able to find it.
she did not, my lord.
Thank you.
Ultimately, the trial judge ruled the confession to be voluntary and therefore admissible. She said that she was satisfied that the injuries on the appellant that had been reported by Dr. Reddy had been explained satisfactorily by the police. She further concluded that the absence of a record by Dr. Reddy or of other injuries or other complaint made by the appellant about having a plastic bag put over his head or having been stomped on by the police disproved the appellant's allegations. And she says, and I'm quoting here, and I'm quoting from page 537, lines 7 through 22.
Sorry, 537.
537.
She says, but as I look at the complaints of the defendant, line 7. In this case, the injuries which the defendant alleges that he was beaten with a baseball bat and he was stomped in the chest area. Those are the two. Water was poured down his throat. He was placed in this bag and a plastic bag was placed over his head in an effort to smother him as his mouth and nose were covered. And whilst on the floor in shackles, one officer trying to smother him, another one stepping on the chain, and as such, he got the injuries. But as I look at the complaints by the defendant and the medical record of Dr. Reddy, it seems to me that the injuries that the defendant complained of are not consistent with the application or the alleged application at all, or the application that he alleges the police rendered upon him. In my opinion, the Crown or the police have given a satisfactory explanation as to how the injuries as noted by Dr. Raju on the wrist, sorry, Dr. Reddy, it's Dr. Reddy, the Crown Counsel corrects it in line 26. The court, sorry, Dr. Reddy, I don't know why I keep saying, anyway, I don't need to read that part. That the superficial abrasion, I think I should take the court to page 530, line 22 to 29. 538, line 22.
Thank you.
So in my opinion, the Crown has reasonably explained the injuries, and as I stated, also, the allegation of the defendant is inconsistent with the injuries he suffered, because Dr. Reddy did not find, or simply in his medical report, had nothing with respect to telling us of the chest area, and according to the report, he did examine, or did a complete examination of the defendant.
Right, this is the judge's ruling on the voir dire, is
Yes,
that right?
Yes.
Yes, it is. So, yeah, and then finally, and the court can look at 8.1 of the further submissions on grounds 4, 5, and 6. And that's 8.1. Finally, if the report made by Dr. Reddy was rightly admitted by the trial judge, that did not dispense with the need for the judge to give the jury appropriate warnings that when estimating the weight to be attached to this evidence, they should take into account the fact that this was untested evidence because the defense had been unable to cross-examine Dr. Reddy about the findings of the report. Okay?
And you say there no such warning was given. I think you said that
Yes,
to Lord Lloyd Jones.
No warning.
Yeah.
So, my lords, those are the appellant submissions on conviction. I respectfully ask that this court quash the conviction of the appellant on the basis that his trial was unfair. In the interest of time, in the event that I missed anything, I commend all of the submissions, the appellant's case on conviction, and all of the supplementary material related over top of been read into the record. I commend those to your lordship. With that, I yield to my learned senior, Mr. Fitzgerald, to present the appellant's case on sentence or supplement the appellant's case on conviction as needed.
Mr. Lundy, thank you very much.
You can sit down. I'll go.
My Lords, I wonder if it would just assist if I just very shortly summarise some points in relation to the lack of representation at the trial, and then go on to the sentence very shortly.
I'd be very happy if you were to do so. Thank you.
Yes, and assisted by my Lord, my Lady's points that have already been made in relation to the Mitchell case and the summary in Maguire. Can I just make these short points as to why leaving him unrepresented meant that he didn't have a fair trial and that the correct test was not applied? Firstly, there was no attempt to reason with him and to reason with counsel so as to get him another set of papers. The, as it were, casus belli was, I want my own set of papers. The judge, we say, quite unreasonably said, you can't have a set of papers, and didn't even say to counsel, well, why don't you go and photocopy one and provide him with that? I understand there's only a limited amount of papers, so there's absolutely no reason why there shouldn't have been two sets of papers, one for the defence, as would happen for the defendant himself, as would happen in this country, and one for counsel. These weren't, as I understand from my learned friend, voluminous. Secondly, there was no counselling as to the gravity of the step that was being taken and its likely impact, which the authorities make clear that the judge should do, should make clear that this is a very grave step to end up unrepresented and to advise the defendant strongly against it, rather than, in this case, the judge appeared to be almost encouraging it. Thirdly, there was no attempt to persuade counsel to stay. It's totally within the experience of all criminal defence counsel that sometimes there are tensions between counsel and the defendant. It's not exceptional. The job of the judge in those circumstances, in our respectful submission, is to say you should sort this out and to try to persuade counsel to stay. Fourthly, there was no adjournment so as to get another lawyer pursuant to the protocol laid down in Mitchell, either to advise him or to take over. Fifthly, the judge did not ask herself the question, which is laid down in Mitchell, whether it would cause prejudice to the defence if the defendant was left unrepresented in a capital case. And the answer would clearly be that it would cause tremendous prejudice. We know that this is someone who had only learnt to read and write in prison, and my learned friend has given you the references, and was of limited abilities in that respect. And then, as my learned friend has indicated, if one asks oneself the question, well, did it have a prejudice, then, as the court has already drawn attention, and my learned friend has very much fully put, there was no cross-examination of Zena Davis on obvious points. It emerged in re-examination that she had been present and seen him lying on the floor being beaten up, and she actually says by the people around were people from the CDU. So there's no doubt that the only people who were beating him up were people from the CDU. And she said that, and that just wasn't picked up on at all. And then the second point we make is that the admission of the ready evidence. We've analysed it in the further note in respect of grounds 4, 5 and 6, but essentially this was dealt with as if it was simply the normal course that someone else comes along and gives evidence of an examination that they never conducted on the basis of notes that they never made, and that's treated as fact. And the Court of Appeal in Stubbs has made it quite clear that Section 120 cannot be read that way, that it must be subject to an overriding duty of fairness. But it was simply put, well, you can refresh your memory from someone else's notes and give the evidence as if it's your evidence. And the possibility of evidence being given by video was not even looked at. And you can see how the defendant was prejudiced by the fact that, one, this was just, you have no objection, do you? This is what we normally do. And two, by the inability then to ask any questions of the person who actually examined him. My lords, my lady, I'm sure that there are many other points that the court itself has noticed, but we respectfully submit that those are the reasons why we would respectfully submit that applying the principles which are helpfully summarised, as it were, synoptically in the Maguire judgment, but also if one applies the test laid down in Mitchell, which my lords, my lady have indicated should be, as it were, a starting point, the test simply isn't satisfied.
So your position, Mr. Fitzgerald, is that even if the board were to infer that the accused had contributed to Mr. Seymour's discomfiture and his wish to withdraw, you still say that the authorities support the view that steps should have been taken which weren't taken and that prejudice resulted.
My Lord, yes, but could I just say on the question of fault, when he says he wants to do it his way, it's not clear whether he's referring to the fact that he wants a copy of the statements himself so that he can, as it were, have some input, which would be entirely reasonable to say, I'm not going to just be, as it were, a layman accepting ex cathedra pronouncements of counsel, that I want to participate.
We don't know, Mr.
We don't,
that this has anything to do with the copies of the documents.
Well, except that he says that's the reason.
Well, yes, but when he's the reference to doing it his way,
yes,
we don't know that that relates.
Well, my Lord, that I accept that maybe, but again, it wouldn't be the first time that in a capital case there's been tension between counsel and defence. The duty of the judge is to say, sort this out. And if the real problem is you want copies, counsel, why can't you just go back to your chambers and photocopy them? And then let's see if that resolves the problem. If it doesn't, and there's something more profound, then you go into the Mitchell issue. But it's not the case that he got rid of his earlier counsel. As my lords have seen, he had withdrawn because of other commitments. And so and my lord and my lady, just one final point, as my friend has taken you through the, as it were, litany of references to, we've got to move on, I've got a case coming next week. There is not the appearance that this was being given the studied consideration that such a massive step requires. And if one looks at those passages, pages 76, 83, 84, 85 and 97, we've given them to you, the judge is repeatedly saying, I've got to move on, this has got to, we can't take too long on this case, I've got another case coming next week. That creates the impression that, as it were, there was pressure of time which was inappropriate in determining this issue swiftly and getting on with the case, rather than, if necessary, adjourning so that he could be advised by other counsel. Yes. I mean, the fact is that Mr. Frederick Smith and my learned friend stepped in the appeal at the request of the court. So it's not as if it's impossible to find counsel who were prepared to step in and assist the court if in a case of this sort. My Lord and Lady, there's a point, just on the sentencing thing, can I just very shortly, if the court would wish to hear me on that issue, can I just yes. Summarise? It's set out in the case, and I think I can take it quite shortly. It's in the case under sentencing, page 2006 onwards. If I can just take it in 4 stages. The first stage is that the judge thought at the sentencing stage that the only alternative was death or life imprisonment. And that is apparent from volume 4, page 1345, and volume 4, page 1345, the judge, paragraph 52, says section 291(1)(a) of the Act expressly provides that since this murder falls within section 292(a) to F, the sentence shall be death or imprisonment for life. Now, an issue of constitutionality arose as to whether a mandatory requirement that it either be death or life would in fact constitute a violation of the prohibition on inhuman treatment because it would leave the judge with no sentencing discretion. And that was an issue which the court has, as it were, the Court of Appeal has looked at but never determined. But it proceeded on the basis in the end that there was a sentencing discretion. So the judge, in that respect, got it wrong, that there was no sentencing discretion. And the Court of Appeal operated on the basis that there was a sentencing discretion to give some fixed-term sentence less than life. And there is a body of case law, in particular the cases of Poitier and Jones, which are cited in the authorities, which basically the Court of Appeal has said that it's more appropriate to give a long fixed-term sentence, and the range is between 30 and 60 years. So we...
Could you just help me on this? The reference to imprisonment for life, is that a mandatory full life term?
Yeah, well, it isn't like our whole life tariff, because they don't have that concept. But the Court of Appeal has said in Poitier that because it effectively is so uncertain what it does mean, it's better to give long fixed-term sentences, because at least the court knows what it's doing, as it were. So that's the approach that has been taken.
So you've no objection to the imposition, to the substitution of a fixed term, but you say it's too long.
Yes, and really the very simple point is that when it came to the Court of Appeal, the submission before the Court of Appeal, which you can see set out at paragraphs 117, is that 117.
Where is this?
EB 2008. So going on from EB 2007 to EB 2008, the submission made in, and this is 117.3, the submission made was that the life sentence was wrong, and that the learned judge wrongly considered that she was bound by a mandatory minimum penalty of imprisonment for life, and that was unconstitutional. Consequently, the appellant invited the Court of Appeal to allow the appeal on sentence and remit this matter back to the trial court for sentencing. And, my lords and my lady, if one looks over at page 2009, that it's set out there is respectfully submitted that should the conviction not be quashed, the matter should be remitted to the learned judge to consider a sentence from 0 years to life in accordance with any mitigating factors and aggravating factors that exist. So the express invitation to the court in the written submissions, which were then adopted orally, was the judge wrongly considered herself bound to impose either the death penalty or life. In fact, she had a sentencing discretion. Since she hadn't exercised that sentencing discretion, the matter should be remitted back to the court for that sentencing discretion to be exercised. And that was the only argument put. We can see that if we go on to page 2010 at 117.7, under heading the hearing before the Court of Appeal. At the hearing of the appeal, counsel indicated he was relying upon his written submissions, which we've just summarised. He made no other oral submissions in respect to the sentencing appeal. Can I just give you the reference? That's at pages, volume 4, pages 1479 to 1480. So counsel was simply submitting, as set out in the written submissions of the 11th of March, the appropriate course is to quash and remit so that a sentencing discretion can be exercised.
So neither court was addressed on the appropriate length of a fixed term sentence.
That's it, exactly. My lord, I should just put one caveat in. There was one reference by where, when the judge, considering herself bound, said, well, if it had, if it were a fix, what would you say? Yeah. Counsel, which is something I myself have done in those circumstances, of course, you're trying to avoid the death penalty. So said, well, 60, because that's the biggest you can get. It's the most equivalent to life. In other words, The judge wasn't exercising a sentencing discretion because she didn't think she had one, but she did say
It wasn't in the context of a discussion about what would be the appropriate.
No, it was a throwaway remark in a hypothetical situation, and so, my lord, then we get to the court.
Where do we see that? The council doing that? Do you have a reference?
Oh yes, we've referred to. We've
1325.
given the reference in the
1325.
1325. Yeah.
Thank you very much.
But that's in the context where counsel is simply saying, well, that's the equivalent of natural life, but not. So that's what's said, and then in the hearing.
Forgive me. On the appeal to the Court of Appeal, the Court of Appeal had the power to substitute the death penalty. On the appeal to the Court of Appeal, when this submission was made by. The reference to 60 years was made by counsel before the judge.
Yeah, the judge was saying, well,
Thank
supposing
you.
it wasn't fixed, what would you say? And he says, well,
Yes,
60
it was before the
because
judge.
it's
Thank you.
the nearest
My fault.
to life.
No, that's why I was asking, because I thought it was being implied that something had been said in the Court of Appeal. I didn't understand that to be the factual basis. It was something said at first instance.
At first instance, my lords, and I say that it's with great respect, it's a red herring. It's referred to by my learned friend, but it's a red herring. Because the context is not, I have a sentencing discretion, what shall I do? Context is, do I impose the death penalty or life?
But presumably the Court of Appeal does have a discretion to substitute a sentence.
Yes.
So might it not be said that counsel was taking something of a risk just to say, well, remit, without actually addressing substantive submissions to the Court of Appeal as to what sentence, if it chose to exercise the discretion, it should impose?
My lord, I would accept that it would have been better if counsel had said, and if you are proposing to do it yourself, then I want to make submissions. But the court never indicated that it was going to take any other course than the court.
So do you say that it was incumbent on the court to indicate to counsel, well, we may want to substitute a sentence?
Yes.
What do you say is the appropriate sentence?
So
The court could see that the appellant was assuming if it succeeded, it would be remission. It was not putting any other alternative.
Yes, no, the court didn't say, well, hang on, we think we've got the power to do it, and will you address us on what you think the appropriate...
Between 30 and 60
Between
years.
30 and 60, yeah, and I mean, one would expect, then you would obviously have some detailed argument. But it was an entirely proper approach of counsel to say that since there's never been a sentencing discretion exercise, the proper approach is to remit it to be determined by the trial court. And also, because the issue is one of constitutionality, I mean, the statute does say the sentence shall be the death penalty or life if you're one of those reserved types of aggravated murder. So, as it were, the focus was, is that right or wrong? And if that it's a mandatory minimum of life. And then if one looks at the Court of Appeal address it, if one looks at page 1479, the Court of Appeal do address what the submission is being made to them. I'm so sorry, that's Mr. Smith adopting his submissions, but the Court of Appeal, it's paragraph 36. Where's paragraph 36 of the Court of Appeal judgment? The Court of Appeal judgment is 1780. And if one goes to the Court of Appeal judgment at page 1797 on sentencing, the Court of Appeal at paragraph 36 under the heading sentencing says, in the event that his appeal against conviction is unsuccessful, the appellant asks that this matter be remitted to the Supreme Court for resentencing on the basis the learned judge incorrectly considered herself bound by the mandatory minimum sentence for murder. And then they say there is no need for this court to send the matter back to the Supreme Court for resentencing. Section 13.3 of the Court of Appeal Act clearly provides that on an appeal against sentence, the court shall, if it thinks that a different sentence ought to have been passed, quash the sentence. Well, the real point is they could only get to that conclusion if they thought that the mandatory minimum was unconstitutional. But they dodged the constitutional issue. They don't make a determination on that. Because there's no doubt that the statute says the mandatory minimum in these reserved cases is life. So you had to go through the exercise of, well, is it unconstitutional or not? And we respectfully submit that they were right to conclude by implication that it was unconstitutional. But then one sees, in a detailed and well-reasoned judgment, the learned trial judge, after considering the relevant authorities, detailed relevant portions of the appellant's probation and psychiatric reports. These reports indicate he has no prior record of criminality. In the opinion of the consultant psychiatrist, he does not suffer from any mental illness. 40. Conversely, the appellant has been convicted of very serious and violent offences, namely murder during the course of a robbery. The evidence of the pathologist report indicates the deceased was stabbed 10 times about the body. In addition to these stab wounds, the deceased's throat was severed by a wound nearly 2 inches deep. The added element of luring the deceased to such violent death by developing a text relationship further exacerbates already heinous offences. Additionally, in the face of overwhelming direct and circumstantial evidence, the appellant remains unremorseful. In light of the principles discussed by this court in Poitiers and Raymond Jones, those are the cases which say it's better to determine a fixed period because nobody knows what life means. But they don't determine the issue. Is it unconstitutional to have a fixed minimum for reserved categories? In consideration of the reference mitigating and aggravating circumstances, we allow the appeal against the life sentence, overturn the sentence of life imprisonment, and substitute a sentence of 55 years imprisonment to run from the date of conviction. And so, as Lord Hamlin has put to me, the range, as we sought to show in the chart of sentences, is between 30 and 60. And if you take a case, just for an example, like the Stubbs case, where the allegation on which he was convicted was of a double killing, including the killing of a police officer.
This is the Stubbs case, which has been before has already been before the Privy Council on one occasion.
And it's coming, back. My Lord gave the judgment, of course, on the bias point. Yes. Well, it's coming back, as it were, to the Privy Council. But just if you just look at that case, a double killing with one of the victims being a police officer, 45 years when the Court of Appeal actually heard argument about the appropriate sentence and imposed 45. So it's not a foregone conclusion that it would have been 55 on any view. And we have assembled the cases in the appendix to the further submissions, if the court has those further submissions on the sentence.
Are you inviting us, if we get to this, to exercise this discretion ourselves, or to remit it?
My Lord, I'm just indicating it's not a foregone conclusion, because one of the arguments that my learned friend puts forward, I respectfully submit somewhat optimistically as well. 55, you simply couldn't come to any other conclusion. But so just to answer that point, can I just show the court the chart? And you can see that there is considerable variety in the sentences, just drawing attention to the Max Tito case, which was before the board on a number of occasions. A killing of 16-year-old girl, victim died as a result of severe head injuries. Her body was set on fire after the killing, left in a quarry 48 years. And then Simeon Bain, of course it was 55 years, but I think it's agreed that the time spent on custody would now have to be deducted, that one sees that. And then if one goes down, Rashid Dean, killing of ex-partner by stabbing 16 times, planned killing and no remorse, 45 years. And then if one goes over Livingston Woodside at page 24, contract killing with firearm, 40 years. And then at the bottom of page 25, the cases of Leon, 45 years for a pre-planned killing with use of firearm. Diane Bethel, murder committed during the course of a robbery, 40 years. Jerome Butler, murder of 81-year-old mother by asphyxiation, 35 years. And then Thaddeus Williams. So, my Lord, I'm not seeking to persuade you what the sentence should be. I'm just indicating that it's simply unarguable that it was a foregone conclusion that it would be 55 years or more, there clearly is quite a considerable range of sentences, even in some of the worst cases which would come within our kind of whole life tariff situations. So we would submit that there was a fundamental breach of the rules of natural justice. There was no hearing, no opportunity to mitigate on the question of sentence. And it was incumbent on the court, if it was proposing, contrary to the submissions before it, to deal with the issue itself, to say, well, what do you have to say on the issue of the appropriate sentence? And my lords, my lady, I do stress that one would have had to go through the exercise of finding that they did have a discretion because the mandatory minimum was unconstitutional. They appear to have, by necessary implication, come to that conclusion by giving themselves a discretion. The only other point we make is that, in addition, we'd say that if you are going to impose 55 years, you should at least give some indication as to why you've selected that particular period, given the maximum being 60 years. But the principal point is the breach of the rules of natural justice. And my lords, my lady, the only other point is that the issue of whether 55 years for someone of 41 would effectively be a sentence to spend the rest of his life, natural life, in custody, that's an issue which both my learned friend and I agree would be better dealt with if the matter is remitted by the Court of Appeal. There is authority in the English Court of Appeal that at least it's a relevant factor if you give a long fixed-term sentence to someone that will result in them probably dying in custody, that's a relevant factor. I think
if you have a 55-year sentence, you could come out when?
Well, 2/3, so it's sort of in your, I think it's 78, yes. But and I understand that there's, Myland Junior, Amanda Cliff Matthews, has done the actuarial assessment of life in expectancy in Bahamas, so which is 70. About 71, 72. So I mean, it may well be the equivalent. But
there is within the Bahamas that regime of release at 2/3.
2/3, yes. And of course, there is the possibility of a presidential pardon.
Yes, I saw that. Yes.
But I can just give you the reference. There's a case called Archer, where in the criminal appeal report sentencing, where the issue was considered about where you get a sentence which will lead to you remaining in custody beyond the age of 80, that can be a relevant factor. That's 2007-2 Criminal Appeal Report Sentencing, page 71. There are a number of cases because, of course, it arises in some of the historic sex cases where they've considered this issue. But my lords, my lady, I don't think I need to dwell on that further point. What we would respectfully submit is there clearly would have been and needed to be quite careful consideration of what the appropriate long fixed-term sentence would be, and there would be issues that counsel, who clearly was acting with the greatest care in the conduct of these proceedings, would have wished to address if they had been given the opportunity. And so we respectfully submit that there was a failure in the principles of in the application of the principles of natural justice. That we've cited the case of Moss, where the board expressed the view that there must be an opportunity to mitigate. That it's set out at page electronic bundle page 2013 at 118.5. Where there was a failure to hear before substituting a fixed-term sentence on substituting a verdict of manslaughter, and the board stated that an omission to hear a defendant before passing sentence is a serious breach of procedural fairness, and that applied at the Court of Appeal stage just as much as at the first instance stage. They then therefore remitted the matter back. And they said that the Court of Appeal was obliged to afford an appellant the opportunity to address it on sentence in order to avoid a denial of justice and a breach of the obligation to hear both parties. So we respectfully commend the reasoning of Lord Hughes in that judgment, which we've set out at paragraph 118.7 at page 2013. Those are really the submissions we make on the issue of sentence, unless I can be of any further assistance on it.
If you succeeded on conviction, would you be saying it should be remitted to the Court of Appeal to consider retrial?
I think it would have to be, yes. I think it would, my Lord. Yes, I think that's the normal course that the board takes. For the yes, my Lord, I think that would have to be the normal course. Yes.
Mr. Fitzgerald, thank you very much for your assistance. Mr. Poole, shall we start after the short adjournment? By my computer clock, it's 1 o'clock now.
My Lord, yes.
Thank you very much.